This is immigration attorney Parviz Malakouti, and in this video I want to talk about a really common issue that comes up. It came up again for me last week in an inquiry, and that was from a gentleman who had a green card and unfortunately got a criminal conviction several years ago. He called me wanting to know if he could naturalize, if he could apply for citizenship. And he scheduled a consultation. We spoke about that, but I brought up another issue, which is as important, if not more important, and that is basically whether the conviction first and foremost makes him removable. So let me back up for a second, okay? So somebody who has a green card wants, of course, normally to progress to naturalization, become a citizen, and not have to deal with any immigration issues. Again, totally understand that, that's important, and we deal with that. But it's always important to remember that when we're thinking about how to play offense by getting that naturalization, first we have to make sure that we're playing defense and we don't submit an application or come on the radar of immigration in such a way that we lose what we already have, in this case, a green card, okay? So if you are somebody that has a green card and you had a conviction before, okay, the first step before thinking about whether you're going to qualify for naturalization is to make sure that you're not removable first, okay? Removability is addressed in the Immigration and Nationality Act in Section 237. And Section 237 lists all the different grounds for which somebody can be removable, which means that for which they can be subject to deportation, AKA removal from the United States. So when somebody comes to us who has a green card, wants to apply for naturalization, we have to do a several part analysis, okay? And you should be doing this as well, at least on your own before you consult with an immigration attorney, just to try to get a little bit of an idea of what's going on, okay? So the first part is we want to see whether this conviction makes the person ineligible for naturalization. A lot of people know that one of the requirements for naturalization is that you have to have shown good moral character within the last 5 years. A lot of people think that that means that if the conviction is outside of the 5 years, that it cannot be considered at all by immigration when you submit a naturalization application. That is false, okay? So our first step is A, what are the chances that this person is eligible for naturalization? B, does the conviction make the person removable? Okay, this is super critical. It's usually not something that can be answered quickly on the telephone. It usually requires a more in-depth analysis by an attorney who's familiar with what's called crimmigration, okay, which is basically a combination of immigration law and criminal law. So the second analysis is, does that conviction make the person removable? The third analysis is there any type of post-conviction relief available for a person that has that conviction? What do I mean by post-conviction relief? I mean basically some sort of relief from the court which erases or undoes, not undoes, that previous conviction. Usually what people think about when they think of post-conviction relief is expungement. And expungement has a little bit of a different meaning in different states, depending on which state you're in. Here in California, usually an expungement is not going to assist for immigration purposes, okay? It's usually gonna take something more than an expungement. Like, for example, a vacatur, what we call a vacatur, a dismissal, okay, based on the merits of the criminal process you went through. Not just an expungement, which is usually something that is accessible when somebody shows that they've been doing good since the conviction, okay? So these are the three analyses that need to be done, okay? First, are you eligible for naturalization? 2, does the criminal conviction make you removable? And 3, especially if the conviction makes you removable, is there any post-conviction relief available so that you can ameliorate the effects of that conviction and hopefully be able to progress to naturalization, okay? The fourth analysis actually is if you take the risk and apply for naturalization, and if you end up in removal proceedings, right, which is not something that we want, but if you do, what remedies are available to you, okay? Some people are gonna have a higher likelihood of having certain remedies available to them if they end up in removal proceedings, and some are not, okay? And it's really important to know that fourth part because that will inform whether you feel it's worth it for you to take that risk to apply for naturalization, right? Obviously, somebody who might have to risk being put in removal proceedings, but if they have a ground of, ground of relief in removal proceedings, proceedings, it's more likely that person's going to feel comfortable going forward with and taking the chance with the naturalization application versus somebody who might find out that they don't really have a strong ground of relief if they get put in removal proceedings. Okay, so that's it for this video. If you have a green card and you're thinking about applying for naturalization with a previous criminal conviction, do not go at it alone. Okay, you need to have at least a consultation with a qualified immigration attorney, if not actually being represented by an immigration attorney. So that's my advice for today. Hope it goes well for you. Stay safe.